Jim, I'm going to step out until you're done.
Okay.
But again, thanks to the panelists for joining us for this. We really appreciate it, your participation.
Thank you.
Thank you.
Well, good morning, everyone. My name is James Cook. I'm the Associate Director of the Asian Studies Center here at the University of Pittsburgh. And I want to welcome all of you to the third and final day of our conference on deals and disputes, China, Hong Kong, and commercial law. That is being co-sponsored by the Asian Studies Center and the Center for International Legal Education. On behalf of both centers, I want to welcome all of you, and I promise that we are going to have a very exciting and strong panel today, our third and final, which is focusing on the future of Hong Kong. Now, we have brought together three panelists, which will be a truly global activity, in which we have Professor Michael Davis joining us from the Woodrow Wilson International Center for Scholars in the Eastern Time Zone with myself, Professor Eva Pills from the Dickinson Poon School of Law at King's College in London, and finally, an old friend to the University of Pittsburgh, Professor Pierre Landry at the Chinese University of Hong Kong. Now, today's panel will analyze the political and legal challenges facing Hong Kong in the aftermath of the implementation of the national security law in June of 2020. And it will review the law's political and legal changes and their effects on the court system, human rights, and the legal profession. I am joined by three, as I mentioned, renowned panelists, and I will introduce them quickly and then allow them to start their presentations. First is Professor Michael C. Davis, again, a global fellow at the Woodrow Wilson International Center for Scholars in Washington, D.C., and an affiliate research scholar at the U.S. Asia Law Institute at NYU, and a professor of law and international affairs at Jindal Global University in India. He spent quite a bit of time in Hong Kong, where he was a professor in the law faculty at the University of Hong Kong until 2016. And his scholarship engages a range of issues relating to human rights, the rule of law, and constitutionalism in emerging states. Most recently, he has published his latest book on Making Hong Kong China, the rollback of human rights and the rule of law in November 2020 from Columbia University Press. He will be joined by Professor Eva Pills, a professor of law at King's College, and also an affiliated scholar with the U.S. Asia Law Institute of NYU as well, and a member of the Center for Human Rights, Nuremberg. She studied law, philosophy, and sinology in Heidelberg, London, and Beijing, and holds a PhD in law from the University College of London. And her current research addresses autocratic conceptions and practices of governance, legal and political resistance, and forms of complicity with autocratic wrongs. Before joining King's College in 2014, she was an associate professor at the Chinese University of Hong Kong. And finally, Pierre Landry, professor in the Department of Government and Public Administration at the Chinese University of Hong Kong, whose expertise lies in local governance, urbanization, development, authoritarian regimes, East Asia, and China. He's been working on several research projects in Vietnam, Tunisia, Malawi, Zambia, and Kenya. And he received his PhD in political science at the University of Michigan before spending several years at the University of Pittsburgh as well. We will first ask Professor Davis to give his talk on the rollback of autonomy, human rights, and the rule of law in Hong Kong. Professor Davis, please.
Thank you so much. I appreciate the kind invitation to participate in this panel, and especially appreciate the fact pointed out in our earlier discussion that all three of the panelists have some Chinese University of Hong Kong background. I was there before I was at the University of Hong Kong. So in fact, in the faculty that Pierre's also in. So very much appreciate this. What I want to do as the constitutional lawyer on the panel, I want to sort of lay out sort of how we got in this mess and sort of, as I do in the book that was mentioned, try to highlight the journey that's going to get Hong Kong in a bind. We know that Hong Kong started out on a very good footing. It was promised very liberal model under one country, two systems. Hong Kong was given a high degree of autonomy. Common law was to be maintained, human rights and basic freedoms under the International Covenant on Civil and Political Rights. The courts were to be independent and final. All of this was guaranteed in a treaty, the Sino-British Joint Declaration back in the 80s, and eventually, as stipulated in that treaty, included in a basic law for Hong Kong. In the book, I highlight actually two flaws that I think sort of gave way to the crisis that always seemed to strike in Hong Kong. One of them is that under this basic law, which guaranteed all these things, and by the way, it was very detailed. It wasn't something subject to whim and interpretation. A lot of the language was fairly clear, you know, in promising the common law system and all of that be maintained. And in fact, it even said expressly that, you know, mainland departments were not to interfere in Hong Kong, and mainland laws would not apply unless they're listed in Annex 3 of the Basic Law. But anyhow, a couple flaws came up, I think, very often in Hong Kong. One is that Beijing had absolute control over interpretation of the Basic Law. Okay, so this meant that when some kind of sensitive issue came up, there would be pressure on the Hong Kong courts. In fact, in 1999, the very first case involving the right of abode in Hong Kong established this kind of superior status of Beijing over interpretation of the Basic Law. And in fact, in that case, the Court of Final Appeal in Hong Kong did not even want to refer the matter to Beijing. In fact, the body that would make these interpretations was the Standing Committee of the National People's Congress. So the court said there was no need to refer it under the guidance the Basic Law provided, that this could be decided locally. It was within Hong Kong's autonomy. And the government of Hong Kong ran around Beijing, the Court of Final Appeal, and asked Beijing to interpret it, and Beijing, in effect, on the substance of the case, overruled the Hong Kong court. I think this power of interpreting and literally being superior to the common law court in Hong Kong, no separate committee, you know, that there was a basic law committee, but it seems to answer only to Beijing. Its proceedings are opaque. No one knows what decisions are made. There's no right to present. So there's not like a constitutional committee or a court to resolve disputes between the local autonomous region and the central government. Central government has total control. The other flaw I think that has plagued Hong Kong has been that the promise, you know, in the Basic Law, there was a promise of universal suffrage as the ultimate aim. So this idea of Hong Kong people ruling Hong Kong and a high degree of autonomy was based on the idea that Hong Kong would choose their leaders. And this democratic reform was to take place in steps under an annex to the Basic Law. And Beijing, using again its power to decide what the Basic Law means and determine and interpret it, drug its feet over this democratic reform. So almost every protest, there were protests in 2003 when the Hong Kong government proposed national security laws under Article 23 of the Basic Law, large, massive protests, over 500,000 protesters. And again, in 2012, when the Hong Kong government tried to impose a kind of patriotic education in Hong Kong. And then in 2014, when the people of Hong Kong were told that they ultimately could choose, have this universal suffrage, there would be a consultation and so on. And there was a lot of distrust that Beijing would deliver genuine democracy under the heading of universal suffrage. So massive protests, the so-called umbrella movement in 2014. And then in 2019, of course, again, we see this massive protest over an extradition bill. But in every one of these protests, democracy always came up ultimately as the problem. Hong Kong people in their wisdom understood that unless they had a government that was answerable to local people, it did not have to be at war with Beijing, but at least it had to be responsive to local people, that unless this was the case, that Hong Kong's autonomy would always be in jeopardy, and that this kind of central government interference in Hong Kong would be a dominant theme. Okay, so this, in fact, many people would believe that the urgency of proposing the national security law in 2003, patriotic education in 2012, and so on, was in effect either to please Beijing or at Beijing's direction. And so also whenever the courts would make decisions that in sensitive areas, or would have cases before them in sensitive areas, you'd always have mainland officials publicly stating their views on what was going on. And this, of course, now has become a major theme under the so-called national security laws that were imposed on Hong Kong last year in 2020. This law really closes the door on Hong Kong's high degree of autonomy. In effect, it's kind of a constitutional amendment in Hong Kong. It revises the Basic Law. It seems to have equal standing with the Basic Law as a national law. And in fact, when this came up before the court in a bail case, the Court of Final Appeal held that it has no power to review the national security law, that the national security law is binding. So it stands almost on a level, virtually the level of the Basic Law of Hong Kong. So while all these guarantees are in the Basic Law, if the national security law is in conflict with these Basic Law guarantees, then it would seem the national security law will prevail. Now that law does a lot of things that the Basic Law did not seem to contemplate. One is it sets up an office for safeguarding national security in Hong Kong. While the Basic Law imagined that Hong Kong would pass such a security laws, secrecy laws, and so on under Article 23 of the Basic Law, the matter that was actually proposed by the Hong Kong government in 2003, this national security law in effect runs right past that and imposes it directly by Beijing in a law that is, by any estimate, very draconian, very broad, very vague. And so this is imposed on Hong Kong, and it was done really without consulting the people of Hong Kong at all. Even the chief executive, we were told, didn't know the content of this law until the day it was promulgated in Hong Kong. So the law sets up a committee for safeguarding national security headed by the chief executive, but this committee is said to be directly answerable to the central government. And it's given an advisor who has already been appointed, who's the head of the local Chinese official in charge of the local liaison office. So it is a mainland advisor and it's answerable to the central government. So the message is clear. The advisor is a bit more than an advisor. In some ways, the advisor can tell people, tell the committee what the central government requires, and one that suspects there will be no resistance. So another thing it does, the national security law does, is it says that this committee can issue regulations for the police and so on how to conduct national security investigations. And these regulations are effectively not subject to judicial review. The committee itself is not subject to judicial review, and its proceedings are secret. And it is to oversee all national security efforts. So it could, in effect, be directing the police. And the police are supposed to conduct their searches in secrecy as well. So there's very little room for challenging what's going on. And the record in the courts so far has showed very little challenge can be successful. Now, on top of all of that, the courts, well, Hong Kong has long relied either on the street in protest or the courts to defend Hong Kong's autonomy. And here, there's a special panel of judges to be appointed, a list of judges to be created to decide national security cases. So any national security case would not be submitted to ordinary judges, but would be submitted only to judges on this list. And the chief executive, who also chairs that committee I just mentioned, is to decide what judges are on this list. And it is said in the national security law that if a judge makes a statement that violates national security, they can be removed from this list. So in effect, how would a judge make such a statement? We know under the common law principles, Hong Kong judges are not out on the street engaged in politics or social activism. If they're going to make a statement, it's going to be in a court decision. And so in a sense, there's a kind of warning to judges, you better stay on the straight and narrow path if you're one of these national security judges, or you might be dismissed and not allowed to hear national security cases again. A footnote here is even public order cases now seem to exist under the shadow of this national security law, to the point where some of the cases where the police really want to go after somebody for the statements they make. And another footnote is that most of the arrests have been for people speaking. It's almost all the national security cases involve speech of one form or another, okay? And so the kind of suggestion in cases involving sedition under the old sedition law, not the national security law, the government prosecutors have asked that also be heard only by these list judges. So the pressure on the courts is pretty severe under this system. And that doesn't stop there. Often either pro-Beijing figures or Beijing officials themselves may be making statements in public that essentially intimidate the courts or suggest to the courts the kind of outcome. Most notorious in this regard is the famous case of Jimmy Lai, who was a very prominent publisher in Hong Kong, published the Apple Daily, one of the leading newspapers in Hong Kong. And he's been arrested because he's long been a social activist. His paper is considered pro-democracy. So he came up for bail, and while denied initially, was then granted by the High Court bail under very strict limitations. And this was taken to the Court of Final Appeal. While that case was pending before the court, the People's Daily publishes an article, that is the official newspaper in China, with a kind of criticism that Jimmy Lai is a dangerous figure, and suggesting that if Jimmy Lai's bail is granted, that they may shift the case to the mainland for trial. And that gets to other parts of the national security law. The national security law doesn't just have a committee in Hong Kong, it has an office for safeguarding national security, and completely staffed by mainland officials, okay? And they get a new building in Hong Kong, and I don't know how many mainland public security and state security officers will ultimately be involved in this. And that office and its staff can conduct national security investigations. And it can assist the police and advise the police, all of these things now. The local special branch of the police on national security, a special branch in the Department of Justice for prosecuting these cases, and an office for safeguarding national security staffed by mainland officials. This office, like the Committee for Safeguarding National Security, is not subject to judicial review. In fact, it is not under the jurisdiction of the local courts at all. And as I promised, it has a provision in there that suggests that if these officers think in a complex case that the matter should not be decided in the local courts, it will be transferred. They can move it. Presumably the chief executive has to be involved, but what we've seen, the chief executive is very compliant with whatever mainland officials want. So if this office wants to move a case to the mainland, it could do so. And that was the veiled threat in the People's Daily article, that they would move Jimmy Lai off to the mainland in the commentary that was offered in this official newspaper. So this kind of threat is not just, a criticism of judges for being too lenient or for dismissing, and often it's criticism for dismissing classic public order cases, not even under the national security law. Judges have been severely criticized over and over repeatedly. So the pressure on the courts is severe. And again, if you imagine, as I suggested a moment ago, that most the guardians of autonomy in Hong Kong have either been the street or the courts, well, there's a large effort now under the national security law, which restricts free speech in so many ways, and now the pressure on the courts, that the ability of Hong Kong to guard its autonomy in any meaningful way is virtually evaporated. And so one country, two systems has been severely weakened. Now, it doesn't really just stop there. One of the things I should add before moving on to talk about the new election provisions, and I'm assuming that Eva and others will discuss some of these cases that have come up. So I've mentioned the Jimmy Lai case. I would say the most notorious case would be the prosecution of 47 opposition figures for conducting an electoral primary, much like they do in the United States. And in doing this, they were said to be aiming to overthrow the government, although all they suggested was if they won enough LegCo seats in the Legislative Council, they would use a provision to block the government budget and thereby force the chief executive to resign and run again. So of course, anybody who's in opposition wants to use whatever the Constitution will allow to try to displace the government in power or to win against it. So anyhow, these 47 are all prosecuted under the national security law, and 36 of them were denied bail because the national security law creates a presumption against bail. And this presumption has been upheld in the Court of Final Appeal in the case I mentioned involving Jimmy Lai. So all of this, in a sense, has resulted in a large sector of the opposition is being either in jail or in exile today, okay? So you would think, well, that might be enough that Beijing now has secured its ground. It's disabled the opposition pretty much, but it didn't stop there. It went on then to enact a new law on elections. And this law is brought into the annexes of the basic law, the provisions that had earlier provided for gradual progress towards universal suffrage. Under those provisions, there's an election committee. And the election committee up to now had 1,200 members. And all they did was to nominate candidates for chief executive and then elect the chief executive. The election committee is a heavily pro-Beijing committee. Okay, it's always been so because the way it's chosen by functional sectors and some officials who are on the committee, it is always like 80% pro-Beijing. So Beijing would largely signal who it wanted to be chief executive. So the democracy protest in 2014 was to try to change that, to have genuine universal suffrage that was promised. But Beijing, in that as an answer to that protest, said that the election committee would still be used to nominate chief executive candidates, which for the opposition meant that no opposition figure could get nominated. Okay, what's happened now in these changes is the election committee has been expanded to 1,500 members. More mainland representatives of Hong Kong and mainland recognized bodies are now choosing those members. And the result is that it's even more pro-Beijing. And the key to all of this that makes it worse is now the election committee doesn't just choose the chief executive, but it also elects, it approves, vets all of the legislative council, okay? And has and chooses 40 of the now enlarged the Legislative Council. It's now going to go from 70 members to 90 members. 40 of those members are elected by the election committee. So they're all vetted by the election committee, and 40 are elected. And a separate committee to vet candidates even vets them before they get to the election committee. And that committee is advised based on the police investigation. So all of the members of the Legislative Council, before candidates for Legislative Council, have to be vetted for patriotism, for loyalty to Beijing, before they can even be a candidate. And of course, once they are chosen or in the legislative body or any other official body, then they could also face risk of being prosecuted under the national security law if anybody judges that they are acting in a way that is not sufficiently patriotic or loyal. The national security law itself prohibits collusion with foreign forces, terrorism, subversion, and secession. So all of these things very vaguely defined. So those things also pose a risk to those candidates. So the question becomes, will anybody from the opposition who's not in jail or in exile actually run, since they're going to be vetted? And my guess is the answer may be no. They're debating whether there should be some reason to try to participate in the process in spite of all these obstacles, because they're going to have to be vetted in effect by their opponents to be candidates. So this is kind of the story. I think the time I've used up, and so it gives you a sense of the dramatic change in conditions in Hong Kong. And under this, all of these prosecutions, I would say, need to be explored not only under the national security law, but under public order laws and so on that seem to operate in the shadow now of the national security law. And I'll leave it at that and leave it for discussion. Thank you.
Thank you, Professor Davis, for that wonderful overview of, well, for a very strong overview of, I don't want to say it's a wonderful series of events that you had to cover. I'd now like to invite Professor Pills to talk on the mainland China's dual state system and the demise of rule of law in Hong Kong. Professor, please.
Thank you so much. Thank you for inviting me. I'm not entirely sure if I can share a screen, but if not, that's not a problem. I wanted to essentially comment on the way in which we can understand the evolutions, the changes in Hong Kong that Mike has so eloquently commented on just now, and that also described in his really wonderful book, by providing a little bit of context from the background of the sort of the topic that I have covered in most of my research, namely the constitutional evolution of in mainland China. And so to try and do that, I hope that I have now successfully shared my screen. I will essentially talk about, I would like to sort of start from the moment of the enactment of the national security law in 2020, that Mike has just interpreted, and sort of see how Hong Kong's trajectory leads us there. And I should probably say at the outset that, and the picture that I'm showing you here, of course, is a very famous image of protesters in Hong Kong holding up these blank sheets of paper. And the sheets of paper are blank because, as Mike just told us, the effect of the national security law has been silencing. It's, in my view, from the perspective of a human rights scholar, primarily a tool to criminalize dissent. And that's why these protesters, of course, are holding up their blank sheets of paper. So to loop back and see how Hong Kong's constitutional system changed and how its evolution led to this point, the enactment of the national security law. I think that we need to think a little bit about the broader political legal background against which this evolution happens, the broader legal political background in China, of the People's Republic of China. And in particular, I think, if we think about the governance system in China, we need to see it as a product of its history that in some ways, from the perspective of a constitutional scholar, really you can divide into sort of three parts. The first, the Mao era, of course, brings the fundamentally Leninist design of the constitutional system, a system that uses phrases such as people's democratic dictatorship, as essentially a system where democracy is claimed to play a role. It is claimed to be the governance system appropriate to the people, but dictatorship is necessary to govern the people's enemies. And of course, it is the party that gets to decide who the people are and who its enemies are. And on the other hand, after Mao's death, there is, and that is really important, I think, for Hong Kong's trajectory, there is, in the 1980s, the introduction of a basic principle of 依法治国, of ruling the country in accordance with law, and it is in many ways a response to the Mao era, which brings so much chaos and a sense of a very strong sense of a need for renewal. And I think that if we took a look at today's constitution of the PRC, so not the basic law that Mike was just talking about, but the constitution of the People's Republic of China, as rewritten in 1982 and revised a number of times, then I think that we would see very clearly a contradiction between the governance principles of the Mao era and the sort of superimposed idea of ruling the country in accordance with law, running through that constitutional system. So my own work as a human rights scholar focusing on the situation of human rights defenders in mainland China has additionally sort of confronted me with what you might call the reality of governance in China. And of course, that reality isn't really fully captured by the provisions of the Constitution, but really it is, one has to understand it as, in my view, very much characterized by the use of arbitrary measures like incarceration and torture. And if we think of governance in China today, then I suppose those terms evoke the image of what is currently going on in Xinjiang with its system for mass incarceration, enforced disappearance, and sadly, according to an increasing body of witness reports, also torture. But the reality of governance in China is, I think, one that is very pervasively characterized by the fact that the coercive state has at its disposition tools of governance that include completely extra-legal, or from the point of view of the legal system, illegal and indeed criminal tools, such as enforced disappearance and torture. And I think that the fact that on the one hand, there has been in the reform era, starting with Deng Xiaoping, an attempt to establish a sense of legality, and on the other hand, the users of wholly arbitrary systems of control has continued is really very important. And of course, as is, of course, the fact that with sort of, especially in the 21st century, in some ways, the opportunities for the party state to exercise control by non-physical means, digital surveillance, pervasive digitized censorship, algorithmic opinion guidance, and so on, in some ways, I think, has given the party state opportunities to sort of expand and update and refine that system. So I think that we can essentially see the mainland Chinese system as a dual system where law and lawlessness, sort of following the law and extensive arbitrariness coexist. And Frankl himself, of course, juxtaposed these areas, these ideas as the normative and the prerogative state, and claimed famously that this system of governance, which he sees as a contribution, he sees as a form of dictatorship, also constitutes an antithesis to the rule of law. Under Xi Jinping, in many ways, the prerogative state has been further strengthened. We can see that not only from the kind of technological updates and the capacity increase of, for instance, the Chinese surveillance state, but also from very clear attempts to change the constitution, to introduce new laws, including national security laws, including the national supervision law and many other legal reforms that essentially provide the authorities with the ability to create exemptions from the legal protections that were to some extent created in the Chinese reform era. So, for example, some of the reforms have created new rules allowing the police, the security apparatus, more easily to disappear people investigated for particular kinds of crimes, including crimes against national security. And here I refer, sort of among other things, to changes of the criminal procedure law that sort of have had an effect of legalizing, as it were, these kinds of practices. So how does that matter as background for the evolution of Hong Kong? Well, I think that as Mike reminded us earlier on, when the Hong Kong SAR system is created by on the basis of the Sino-British Joint Declaration and by establishing and enacting the Hong Kong Basic Law, I think in some ways we are in an era of comparative, relative optimism for the mainland legal system. And I think, after all, sort of the negotiations start under and with Deng Xiaoping as a negotiating partner. And although obviously there is the terrible and deeply concerning, as it were, interruption of June 4th that absolutely shakes Hong Kong and shakes Hong Kong's confidence in mainland China, I do think that it is really relevant that the system of the Hong Kong SAR, as it is created, sort of holds out this hope that it might remain a kind of rule of law enclave. And I fully take on board everything that Mike has said about the various ways in which that enclave was compromised. In particular, of course, we could look to, as Mike did, the immigration cases, Mgaling and so on, and we would instantly see that from the outset of the system, the mainland authorities create means of encroaching, for instance, upon judicial autonomy. But nevertheless, I think that the fact that freedom of expression, that various democratic rights fundamental to a vibrant civil society are comparatively so well protected in Hong Kong, of course, is deeply relevant to the idea that it might somehow not only survive, not only indeed further evolve in the sense of the kind of democratization that the Hong Kong Basic Law in its provisions on universal suffrage and so on certainly holds out, but also, and I well remember sort of being presented with that perspective when I moved to Hong Kong, the Chinese University of Hong Kong in 2007, also in the sense that actually Hong Kong could be seen as a model for mainland China's potential further trajectory towards rule of law and constitutionalism and so on. I remember both mainland constitutional scholars and Hong Kong scholars sort of essentially expanding, sort of elaborating that particular perspective, illustrated here by a title page of an article from the 1990s, Hong Kong's influence on China, the tail that wags the dog. Of course, when we look at how that story continued, especially in what in mainland China is sometimes referred to, has been officially designated as a new era, the new era of Xi Jinping, then I think it is very clear that fundamentally the evolution of Hong Kong is a response. It's determined by the reversal of the direction of legal political changes in the mainland. And I mean, I think that we've heard so much from Mike already about how exactly that the last couple of years lead up to the enactment of the national security law for Hong Kong, that I don't want to repeat too much. I certainly think that it is very obvious that at the very moment when the situation in mainland China deteriorates, starts deteriorating very badly, you can see that sort of return of deep nervousness and disquiet in Hong Kong civil society. The tail very clearly no longer wags the dog, or there's just absolutely no hope of Hong Kong, the Hong Kong sort of rule of law ideas somehow guiding reforms in mainland China under Xi Jinping. And I mean, to reprise the evolution in mainland China that kind of accompanies what happens in Hong Kong in those years, I would just point out, and a lot of my my work on with human rights defenders in mainland China, of course, had to focus on that. We see very quickly under Xi Jinping a rejection at the level of rhetoric, of ideas of rule of law, of civil society, of universal values, human rights, and so on, followed swiftly by several campaigns against civil society, including human rights lawyers, including journalists, including, in a sense, the whole of academia, and indeed also advocates for, incredibly moderate advocates for better respect for autonomy rights on Hong Kong's periphery, And of course, I'm thinking not only of Hong Kong, but also of, for instance, the Xinjiang Uyghur Autonomous Region. It is in 2013 that the persecution of Professor Ilham Tohti sort of gets worse, and he's of course arrested in 2014. From my perspective, the most prominent mainland advocate for greater autonomies for the Turkic Muslim ethnicities in Xinjiang, and similarly persecution of autonomy advocates elsewhere within the sort of PRC mainland jurisdiction gets worse around that time. And it is around that time that Hong Kong civil society then starts sort of responding, and that we have the creation of the idea, we have the launch of the civil disobedience movement, and responses from the central authorities that include, very importantly, in 2017, this declaration, the statement that the Sino-British Joint Declaration no longer has meaning, the June 2019 protests. From my perspective, taking this back to a dual state analysis can really be seen as protests by a very knowledgeable, very aware Hong Kong society against an extradition bill that really would have brought the prerogative state, the state of arbitrary measures, into Hong Kong's criminal justice system by essentially creating a mechanism for sending people from Hong Kong into the mainland China's criminal justice, which is so deeply compromised by practices of including enforced disappearance and torture. So, so the national security law, which I will not in detail analyze because Mike has done that, I think fundamentally is also an attempt by the mainland authorities, the central authorities, to establish a prerogative state, a state of arbitrary measures in Hong Kong, because of this introduction of a kind of new institutions that allow for complete reduction of procedural safeguards and the criminalization of dissent through the introduction, of course, of criminal offenses, as we have already heard. And I think that I would only note, in addition, that in addition to the further sort of attempts to, if you like, de-democratize the system that have already been outlined, from my perspective, it is also really concerning that the further attempts to bring the judiciary under control seem to be still happening. I think that we've had, for instance, these interesting but also deeply concerning announcements during the last November's Basic Law Legal Summit by participants such as Zhang Xiaoming, that it was necessary to introduce further judicial reforms. And I think that that might be one of the sort of, if you like, next the next concerning developments to further dismantle Hong Kong's constitutional system. So in conclusion, I would just say that I can, of course, only agree with Mike that these developments are very deeply concerning. And I think that the fact that that sort of we are at this point in Hong Kong's legal political evolution in many ways is merely a reflection of the fact that autocracy in mainland China has deepened, that the system has taken on somewhat neo-totalitarian features, and that is affecting Hong Kong. But if I take from if I try to draw on the lessons of having studied human rights defense and civil society resistance in mainland China for so many years, I would also say, returning to this image of the protesters holding up blank papers, that even a highly repressive system like the mainland one is not able fully to suppress demands based in liberal principles of human rights and constitutionalism. And it's very clear that Hong Kong civil society, in comparison to that in mainland China, is much stronger because it was allowed to develop and become very robust over such a long period of time. And so I think that we are very likely to see opposition to these changes in Hong Kong continue, even though we must expect, and I think we are already seeing, that it is changing its forms. And for that too, perhaps this holding up of blank pieces of paper is a pretty good illustration and symbol. So I will stop here. Thank you.
Thank you, Professor Pills, for that, in my opinion, incredibly insightful presentation. I deeply enjoyed how you made the connections to not only current events, but the history of law in mainland China. Now I'd like to turn over our discussion over to Professor Pierre Landry. Professor Landry will be talking about politics in Hong Kong under the national security law. Pierre, please.
Oh, thank you, Jim. I'm trying to share my screen. I hope you are seeing it.
Not yet.
Not yet. Okay. How do I make that happen? Why is this not working? I'm so sorry.
It was there a minute ago. You did something that made it go away.
Oh, that's not good. Share again.
Share again, yes. There you go.
You got it? Okay.
Yes.
Okay, so thank you so much for inviting me. It's always a pleasure to reconnect with Pittsburgh and to connect to my colleagues who used to be here. I am not going to repeat or rehash some of the very, very well done points and presentations of other speakers yesterday, as well as this current panel. And I am not going to even address the legal questions specifically, and instead try to wear my hat of a political scientist to try to understand the possible ways in which the Hong Kong system may evolve over the next few years. It's a very difficult task. I often criticize my students when they try to write what I call crystal ball social science. It's not an easy task, and it probably should not be done. I will never forget the day when I was in my first year of college, when my esteemed history professor, the day after Gorbachev was elected General Secretary of the Soviet Union, told us that Gorbachev had to be the youngest of the elders and would implement exactly the same policies as the leaders who had just passed away. That unfortunate prediction has stayed with me over the years as a mega warning that we should be very cautious about forecasting the future. Let me start with this day, December 9th. Yes?
Here, if you could hit start slideshow, then we can see the full screen.
Oh, sorry. Is that it? No. Start. Oh, dear me. Where is this on this computer?
It's the button right beside the 87% at the bottom. Your left.
Left.
Yep,
Oh, I
yep,
see.
right, right.
This,
Yeah,
Yep,
all
right
right,
there.
sorry.
you go.
So this is the picture of the signing of the Sino-British Declaration on December 19th, 1984, with Margaret Thatcher and Zhao Ziyang, who presided over the ceremony. And I want to emphasize that this is a really important point to remember. The negotiations between the UK and China and the content of the Sino-British Agreement were effectively a political agreement between two heavily calculating systems that had very different goals at the time when they decided that it was appropriate for them to do something about Hong Kong. Prime Minister Thatcher was not particularly interested in Hong Kong and was simply trying to get rid of the hot potato as quickly as possible in the ways that would be the least damaging to the reputation of the UK, and did that by making choices that were not very popular in Hong Kong. For example, not allowing the right of abode for Hong Kong residents to the UK following the departure by Britain in '97. By the way, in contrast to what Macau has available to its citizens, since the Portuguese government, under a similar agreement with China that came into effect in 1999, offered Portuguese citizenship to the entire population of Macau if they chose to take it. The Chinese side was also a very different type of leadership. Zhao and at the time General Secretary Hu Yaobang were probably the most open-minded, liberal, and reform-oriented top leaders, beside Deng Xiaoping himself at the time, in wanting to take China to a very different place, and really saw Hong Kong as an opportunity to draw on the experience, the human capital, the expertise, I mean, you name it, that Hong Kong represented that could help propel China's development, not just in the South, but for the entire country. And so they were willing to make very significant concessions about the ways in which the party would not rule Hong Kong in the way it had ruled the rest of the mainland since 1949. In exchange for very obvious perceived benefits of the agreement. Now, the problems accumulated, unfortunately, very rapidly after 1989, not only because it demonstrated a side of the Chinese regime to the world and to Hong Kong that was most unwelcome, but it also entirely upturned the leadership itself and gave the keys to the palace to a new team, Jiang Zemin, and then soon after Li Peng was sort of sidelined, Zhu Rongji, who governed China for the next decade or so. And of course, they had to worry about other things. I mean, their position was, well, the regime in China had just gone through a very challenging phase. They had almost lost power. And they were to really rethink very carefully whether situations like Hong Kong were sustainable from the perspective of leaders whose job it was, when they were brought to power by Deng and the elders who effectively to engineer that transition in 1989, to ensure that the Communist Party of China would remain in power, unlike its brothers in the Soviet Union and Eastern Europe, as basically the walls collapsed around the communist world in the early 1990s. So Hong Kong looked a lot more problematic after 1990 than it did in 1984. Moving forward, the handover in 1997 occurred at a very strange time. I remember being here a few days before it actually took place and watching it on television, and also seeing through the early phases of the financial crisis. Hong Kong had a complicated move into Chinese sovereignty. There were tremendous anxieties about how the party would govern, and that led to a wave of out-migration between '84 and very specifically after 1989. When the handover happened, the economy of Hong Kong, particularly the real estate sector, suffered greatly. So it was a very unhappy moment in many ways for the economy. And so it was really complicated for Beijing to ensure that there would be a success. And I think to the great credit of the Jiang government, they really were very careful during their entire time in power to really emphasize the economic value of Hong Kong and to emphasize the need to preserve the core institutions that sort of support the Hong Kong economy, the Hong Kong dollar, fully convertible currency, the banking system, the stock exchange, you name it, right? Even going so far as to hire a Hong Kong citizen to advise on their own regulatory commission in Beijing as a minister level appointee, which was quite unusual at the time. Now, the problems that Hong Kong ran into, unfortunately, are not a sort of a one-time switch. It's not like everything crumbled in 2019, but there has been a very long evolutionary process of gradual decay. Professor Davis mentioned that earlier, and I'm not going to repeat the key highlights of the problems that occurred from Article 23 demonstrations and legislation that never happened through the 2019 events. I think you've mentioned every single point that I was going to make here. But what I want to emphasize is that the difficulties that have occurred over the decades, now the 2 decades when the one country, two system lived, were really the product of a very bad document, right? The basic law, with all due respect to its writers, was full of extremely problematic sort of loopholes, and we have seen since the government taking advantage of them, such as the reinterpretation business, did not really create a system with understandable Supreme Court for Hong Kong, did not really address the question of how the chief executive was going to be elected, and kind of left open the possibility of universal suffrage in the future, but never really defined and did the work, at the time, or guarantee that there would be such an election. And even the Legislative Council, that came into operation in 1997, was a very strange body. If you remember, the British government, very late in the game, under Governor Patton, decided to hold universal elections for LegCo in 1993 in Hong Kong, which infuriated Beijing because that was not part of the initial agreement. And so the UK effectively allowed this one-time open election that was a very important moment in the political development of Hong Kong, but was extremely problematic from Beijing's perspective, because Beijing had no intention of taking over Hong Kong with a LegCo that would be entirely elected by the average population. And so it announced that it would establish a preparatory committee based in Shenzhen, and on the day of the handover, that committee arrived in Hong Kong, replaced the LegCo, and LegCo, as it had existed, was disbanded and returned to the pre-Patton system that we have known until very recently. So there were really grave difficulties because the rules of the game were never fixed. And it was in everybody's interest in 1984 to sweep those details under the rug for short-term political needs. And to think that basically things would sort themselves out naturally after 1997. And of course, bad institutions have bad consequences, and bad designs fail. And in many ways, the system failed repeatedly throughout the 2000s and escalated to the point where we have seen this major meltdown over questions like education reform, umbrella movement, and so on. This, by the way, is a picture of my colleague, Professor Kinman Chan, at the time of the Umbrella Movement, when he was about to be tried, I believe. I think it was taken in front of the courthouse. He was sentenced to a jail term, which he completed for his role in the then Umbrella Movement, not the 2019 situation, as well as here Professor Benny Tai from Hong Kong, formerly from the University of Hong Kong, who was dismissed by his home university after he was sentenced, who is now back in detention because of new indictments based on the national security law, etc. All of the people in the background are well-known figures in Hong Kong. But the problems that occurred under the Umbrella movement, in 2014, were not new, right? They were built into the basic law itself, and the fact that it never really provided for a credible mechanism to solve it. So the way I see these questions now is more like as a sort of cynical political scientist, and I'd like you maybe to introduce those of you who don't think that way to sort of a very rudimentary cost-benefit analysis. This has to do with trying to put yourself in the shoes of a leader in Beijing, right? If you are Jiang Zemin or Hu Jintao or Xi Jinping, why would you care about Hong Kong, and how much should you care about Hong Kong, and what are the factors that are going to drive your decision-making process as to what to decide on a daily basis? There's no question that Hong Kong historically was valued by Beijing for its role as a financial city, as a financial center that could be very helpful to the People's Republic. And this goes back to way before the 1984 agreement, when institutions like the Bank of China and other Chinese players were already present in Hong Kong and were able to maintain a presence in the post-war era, apart from the brief moment, well, not so brief, but the Korean War sanctions. But basically, Hong Kong was very important to channel capital into the mainland and to bring advice and to bring tech know-how and trading opportunities for, at the time, a relatively closed economy. And so it was really the lifeline of the Chinese economy to the greater world. After 97, because of the importance of capital investments to growth in China, having control of a city with such an important financial market was, of course, extraordinarily important. It is also very important for the ruling elite in China, both economic and political, to have a conduit through the Hong Kong dollar to move money around, both in and out of China, in ways that is not usually possible for typical citizen. And thanks to giant loopholes in how transactions are conducted between the mainland and Hong Kong until very recently. I mean, some of those laws have been changed, but it's been remarkably easy for people to move assets in the renminbi assets, to magically convert them into Hong Kong dollar assets across the border and park them in Hong Kong or move them further away if necessary. So we should not underestimate that valve and its importance to the people who are ruling in China and sit often on very significant economic resources. So that's the benefits, and there are lots. You can think of many other kinds of benefits, but let's keep things simple. These are material, potentially very important, and that may even affect the direct lives of some of the most powerful people in China. The risks, however, are not trivial, and I think we need to not lose track of the reality that the Chinese regime is fundamentally a regime that has the problem that all dictatorships has, dictator's dilemma. You never know that you are not popular until you are out of power. You never know that your allies are not your allies until they edge you out of power. because it's not in anybody's interest to reveal their preferences. So regimes of that nature are inherently fragile, even if they don't appear to be fragile, but have a tendency to experience very turbulent political crises. And you can think about, for example, the transition from Khrushchev to Brezhnev in the Soviet Union, or the multiple sort of mini coups that occurred across the communist regimes of Eastern Europe between 1948 and 1989. Now, Hong Kong is potentially a risky area. The regime was certainly not going to be very interested in having a kind of a lingering opposition in Hong Kong for a very long period of time that could, point the finger at all of the problems, historical and contemporary, that beset the Chinese regime. June 4th was one of them, on the marches that took place every year. But you could also think about, how people think and write about the Cultural Revolution, how people think and write about the Great Leap Forward, and all of these inconvenient historical moments in the development of the party that are widely debated in Hong Kong. Second, much more important risk was the possibility of contagion from within Hong Kong to other provinces, not just Shenzhen and Guangdong, but China as a whole, because of increased movements of people between the mainland and Hong Kong in both directions. And so the possibility that mainland tourists would come and experience a very different political system in the language they are familiar with and take those values home is something that the regime absolutely wanted to avoid. And it does that because it is very sensitive to the possibility, however remote, of any existential threat to single party rule, right? So it has to run a kind of a lottery, right? This is the well-known kind of Bayesian expected utility kind of world where, there's benefits that accrue with a probability p, there's a cost that might accrue with a probability 1 minus p, and you got to be sure that sum it remains of a positive value, right? So if you really worry about the costs, if you are very risk averse, as the regime in China has been in recent years, and they are extremely risk averse, you really de-emphasize the benefits and really magnify the costs of not harmonizing Hong Kong or normalizing it, to use a Brezhnevian term that was applied to the Czechoslovakia at the time. Now, to focus the minds, I think this is perhaps the most important chart to summarize the history of Hong Kong recently, is basically the idea of what was Hong Kong like in the early 80s. The Hong Kong economy in the early 80s represented about 10% of the Chinese economy. And surprisingly, even after the short interlude of the early years following the signing of the Sino-British Declaration, the share of Hong Kong in China's economy rose to as much as 27% of China's GDP by 1993. And so it became a massive engine, right, growing kind of at such a fast pace that it was really very important. And China, in relation to Hong Kong, was actually not such in a strong position and really needed this kind of economic support at a time when there were profound questions about the future of reforms between June 4th and what corresponds to Deng Xiaoping's famous Southern tour, the Nanxuan trip in 1992-93, I'm forgetting the exact date, which marked the kind of relaunch of the reform program, the work towards WTO membership, and the great acceleration of Chinese economic growth. After 1993, so a few years before the handover, we see a very steady and rather precipitous decline in the importance of China, of Hong Kong, as its share of the Chinese economy. Not that Hong Kong declined. It's not that, everybody got to starve in Hong Kong. Life is pretty pleasant. But the growth of China was so extreme and so rapid that as a share of its expanding GDP, Hong Kong's proportion shrank, and has now shrunk to below 3%. So if you think about that, it also means that from the perspective of someone who is ruling China, Hong Kong is a pesky problem today, not an overwhelmingly important issue as it was in 1993, right? And so when we see extreme measures being taken, fairly brutal ones, it's not too surprising that the government is not exactly wearing white gloves when it's handling precious Hong Kong, because Hong Kong has become much less precious to the government in Beijing. And hence, what we have now seen as things like the national security law. I'm sorry for the non-translation of this Chinese document. This is a summary of emigration out of Hong Kong following the Sino-British declaration, the early years of this massive outflow of people. But as you can see, since 1997, in fact, the out-migration from Hong Kong has not been very large, right? We will see what happens now. But we know that one of the responses that Hong Kong society has to bad governance, or the risk of bad governance, is to check out. This is really putting into practice the famous exit, voice, and loyalty problem that Alfred Hirschman wrote about. If you don't have voice, if you can't activate politics, the market will clear, and people who are distrusting of local institutions or think that they will be comparatively better off elsewhere will move. And Hong Kong has a record of doing that, and I think we can expect another wave of migration, particularly since countries like the UK have facilitated immigration into their countries from Hong Kong. So where do we go from here? What are the kind of core variables that may influence Hong Kong in the years to come? The first thing to point out is that Hong Kong is not one of them. In other words, Hong Kong is no longer relevant to its own future. The future of Hong Kong is in Beijing, and it's almost entirely in Beijing's hands, and Hong Kong has lost virtually all agency in that process. And we have to be very clear, the one country, two system does not exist anymore. The rule of law system has collapsed, and Hong Kong is entirely going to be governed from the perspective of people in Beijing who have to make the sorts of calculations I just presented. Of course, will China change? Will it change in a more liberal way in the next few decades? Or will it continue the trajectory that we have seen since 2012 of a hardening regime? It's very hard to say, but basically, if Beijing becomes a more liberal, if China becomes a more liberal system, so will Hong Kong, and if it remains, or even it becomes even less open than it is today, Hong Kong will suffer accordingly. A question that's going to arise pretty soon is the status of 2047. Before this entire meltdown, there were, pronouncements by Beijing officials that the 50-year window that Deng Xiaoping had uttered, 50年不变, right, no change for 50 years, was in fact no change for at least 50 years, but that somehow the date of the final conversion or convergence with the mainland could be extended. We're not hearing any of that stuff anymore. And of course, the relevance of 2047 is greatly diminished now that the basic law has been eviscerated. So it's entirely possible that a greater moves towards integration of Hong Kong into the mainland space as a normal city in a normal province may well occur, right, in the next decades. US-China relations may play a role, but I don't want to overemphasize the role of foreign players here. I think this is going to be primarily a Chinese affair. If we move to Cold War II, as we seem to be doing by the day, it's possible that China will rethink the importance of Hong Kong as a financial center, particularly if that involves on the part of Western powers efforts that were initiated by the Trump administration to close off China from some of the key elements of the world financial system, or not allowing Chinese corporations to list in New York and on Western exchanges, for example, could really highlight the importance of a credible stock exchange in Hong Kong to sustain the Chinese economy, even with severe restrictions from the West. So it's possible that one of the sort of unintended consequences of worsening Sino-US relations could be that Hong Kong will be, in fact, somewhat more important and to Beijing than it is today. It will also depend on developments in Asia and how much of the current divergence or decoupling that we are seeing between the US and China and between China and OECD, broadly speaking, also occurs within Asia. And that will, of course, mean that either Hong Kong will be useful for the regional community or may be useful, or they may simply just be cut off. We don't know that, right? Taiwan is one of those big key questions. One of the things that makes me very pessimistic about the future is that we used to believe that one of the big constraints or self-imposed constraints that the Hong Kong sovereignty by China implied was that China had to behave in Hong Kong in order to ensure that the idea of unification with Taiwan was plausible and that there would be enough support in Taiwan for a deal, presumably between the KMT and the CCP, in an environment in which the KMT would be in power in Taiwan, pointing at the fact that things had worked out really nicely in Hong Kong and that the Taiwanese had nothing to fear. Obviously, the world today is in a very different place. Taiwan is in a very different place. The DPP is governing it. And it's not clear that there is anything now that can be done to tell the Taiwanese population that the Hong Kong China relationship is so great that they should emulate it. That is a potential grave concern because it could mean that Beijing has decided that the only way to take Taiwan is force, and we could see the possibility of violence as a result. And I'm very worried that basically the death of one country, two system will effectively mean the death of any possibility of cooperation between Taiwan and the mainland, and the relationship will be increasingly militarized. So I'm not, as most speakers who have spoken in the past few days, I'm not particularly optimistic about the future. I think we're up for some very, very rough times within Hong Kong society, between Hong Kong and the mainland, and between the greater China space and the international community as the dust settles, and it will settle very slowly. And I will stop here. Thank you.
Thank you, Professor Landry, for your presentation and also the very important reminder of Hong Kong's place in terms of Beijing's historical calculus, so to speak, and how that has changed over time. We've received several questions, both in the chat as well as the Q&A. And I want to encourage the audience to submit additional questions in the Q&A. I'd like to start with the question that one participant has asked about. Some commentators point out that the national security law contains provisions stating that human rights will be protected under the law. Will the Hong Kong courts be in a position to rely upon these provisions to safeguard human rights in NSL cases? And I'm sure Michael and Eva may have some comments on this particular question.
I'll start since you said my name first. Yeah, I think this is there, and it's often pointed out that it's there in Article 4 of the National Security Law. But I have to say I'm somewhat pessimistic. I know some colleagues in Hong Kong U have, and former colleagues from Hong Kong U have argued that the courts will do their best to use this wiggle room. And so when they interpret other provisions in there, in fact, the 4 crimes themselves, they may try to interpret them in a human rights sensitive way. But the very first time the Court of Final Appeal got this on its plate, it was threatened, as I mentioned in the People's Daily, to get it right the way Beijing wanted it. And it said that the bail provision, which violates Hong Kong's provision, which historically presumed a right of bail, and that you're innocent until proven guilty, it went the other way and said, well, no, this is an exception. The NSL has created an exception, and that exception stands. And so many of these people who most of us know pose no threat to society are all locked up and denied bail. So I'm somewhat pessimistic. Yeah, sure, if I'm a defense lawyer, I would say use that article and get the best interpretation you can. That's without question. But whether the courts are going to go along with it, I have to say is another matter. Eva,
should I add? I mean, of course, I do agree with Mike. I would perhaps only add that I think in a system with a fully autonomous judiciary that didn't have, that wasn't affected by, the novel processes of selecting judges and the kind of overall threat to the system that come from Beijing, I would also think that one could expect the judiciary to engage in very robust review of the NSL itself. In particular, for example, Article 29, one of the criminal provisions, which basically criminalizes stoking hatred against the government, against the central authorities or the regional government. That, of course, by itself is so much a speech crime that in light of the basic law, the fundamental rights protected in Hong Kong, I think it ought to be essentially rendered sort of deemed sort of in violation of constitutional rights. But I think that we cannot expect that to happen, and we haven't seen any indication that the Hong Kong judiciary will be capable of this kind of, in a way, straightforward liberal rejection of a deeply illiberal law.
in fact, I would add just to her point that the Court of Final Appeal specifically said that it has no power to review the national security law under the basic law. The national security law, in effect, is on equal ground or superior ground to the basic law. There's no review of the national security law.
And I think that, I mean, in technical terms, that surely is the perspective that the mainland authorities would take. And yet, that, of course, means that precisely the human rights provision within the basic law, neither the human rights provision within the basic law nor the existing international obligations or constitutional safeguards, according to Hong Kong law, actually play a role for the judiciary.
Thank you. So I'd like to combine sort of two questions here that I've received, one from Professor Brand as well. Given the concerns raised in this panel, what do the panelists see as the future of Hong Kong as both a commercial financial center and as a player in commercial dispute resolution in Asia? Will business largely move out of Hong Kong? And we had another individual make the point that the 2021 International Arbitration Survey published by Queen Mary University of London shows the position of Hong Kong going up to third in the most preferred arbitral seats from fourth position in 2018. So how will the national security law affect Hong Kong's place as a seat for arbitration, do you think?
I would defer to Pierre first because he's offering the political. I have a view on that, but I'd like to hear his.
Well, I mean, there was a survey by the American Chamber of Commerce that just came out last week, asking participants about their plans for the future, and as many as 40% of the responding firms stated that they are thinking about leaving Hong Kong due to their concerns about how the NSL will be implemented. So it's a grave risk, and I think I would not take a report 2 years ago based on data collected 2 years ago as a good forecast of the next few years. We've seen, for example, how in the area of, for example, the most recent press freedom index, things have really changed very, very, very quickly. The economic freedom index by Heritage Foundation that used to categorize Hong Kong as a very free economy no longer even considers Hong Kong a separate entity and has dropped Hong Kong altogether from the index. So there are grave concerns that Hong Kong will not be a distinctive place. On the other hand, it may be as attractive as a large, somewhat cosmopolitan, fairly developed coastal Chinese city, and there are several of them. The question is whether it will regress to that status quickly, or if it will still be able to have a cachet of having been a different place where maybe arbitration and mediation cases can occur. But I'm not very optimistic.
Can I add here that I think even Hong Kong's major companies will feel more and more heat. They've been put under pressure to embrace the national security law, to declare their support for it, and they are rewarded with appointments and so on. But in the US Congress, laws have been passed that would enable sanctions of companies seen to do exactly that. So they're really put between the rock and a hard place. So not just the international companies, but even the Hong Kong's major companies may face a very difficult choice of how to navigate between two major powers.
Thank you. We have another question from Margaret Wu asking, could you please comment on the idea that what is happening in Hong Kong is a transition, that China is trying to remake Hong Kong along the model of Singapore's one-party authoritarianism, albeit roughly, rather than evolving into democracy as Taiwan. After all, Hong Kong remains important as a capital financial center, and Taiwan unification looms in the future. If that is the ultimate outcome, what are the risks and benefits for Hong Kong, and would this be an acceptable outcome to Hong Kongers?
I can start. I just would want to concur with what Eva has said, that in effect, the mainland system, not the Singapore system, is being imported into Hong Kong. And it's one where officials will retain a lot of discretion over anything they want to do. And where Singapore hives off a bit of the political discourse and suppresses it, but otherwise works vigorously to maintain rule of law across the board. I think the comment I just made, that companies are put under pressure, shows that a kind of corruption where you go along to get along is intruding into Hong Kong's business community. And so I don't see Singapore as the end of this journey.
I would only add to that, but I think we can also draw on so what was observed earlier by Pierre. I think the role of Hong Kong for mainland China and for perceived needs for stability for the whole of China really plays into that. And there is no chance that the mainland authorities would want to risk allowing continued civil liberties, even sort of at the minimum that I think would be necessary for Hong Kong society to continue to continue in a sort of viable sort of way. And so I think that the idea, and even if you look to what the national security law has done in terms of the prospect it opens up of a criminal process in mainland China, and the way it sort of is corrupting the criminal process within Hong Kong, I think that that is so much a move towards what I've tried to characterize as lawlessness of sort of extensive arbitrary powers, that it's very difficult to frame it in this idea of authoritarian legality. Whether that idea works for the Singaporean system, I think, is another question. But fundamentally, my answer would be no. I don't think that that is a potential endpoint for Hong Kong's development.
And in fact, Singapore has become an outlet for people to think about as a place to move to, away from Hong Kong, which is an interesting irony because there was the reverse a few decades ago. But certainly, I think Singapore would be a glorious, positive outcome if it were to happen under the current institutional design. But I think the probability of that is exactly zero, right? Not in the cards.
Thank you. We have a question from one of the panelists who joined us yesterday, Professor Julian Chase of the City University of Hong Kong. And he asks Professor Landry, what is the impact of the Greater Bay Area, GBA, on Hong Kong's future? Is the purpose of the GBA to fully integrate Hong Kong into China?
Yes, it is. It's basically an effort to try to make Hong Kong people kind of realize the benefits, the potential economic benefits of deeper integration with South China, and particularly the Bay Area region. In a way, it is. I call this a Marxist view of the world, with 21st century characteristics, in which basically Hong Kong people are supposed to embrace the mainland purely on the grounds of economic well-being, regardless of any other dimension of daily life. And it's expecting in particular the young people who are having a hard time finding jobs in Hong Kong to walk to the other side and be employed by Chinese companies in the PRD, and to even buy real estate that they cannot afford in Hong Kong and find cheaper apartments in Huizhou and places like that. It is not an appealing model for the average Hong Kong citizen. You speak to every students I've been speaking to and young people. That's not the choice they are willing to have to make in order to have a better life. And so it will happen, I think, because the forces of economic powers are overwhelming. People will not willingly do that, but I think inevitably the borders will come down. And the long term of Hong Kong may well be to be one of such cities, in the Greater Bay Area, perhaps with a new institutional design or innovation that we can call some kind of massive, Kai Fat Shu of the mid-21st century, a new development zone. That would be, an enormous area in which Hong Kong would be just one of the minor players, and that may well be the plan.
Michael or Eva, do you have any comments on this?
Well, I actually want to sort of tweak Pierre's risk, the three risks that he highlights that China perceives. I think he's right that China perceives these as the risk. I think their judgment is very bad on that. I think by incorporating Hong Kong into China more, they increase the risk that whatever goes on in Hong Kong or whatever, when mainlanders come to Hong Kong, they will see something that they should be entitled to, a better lifestyle and so on. Where when Hong Kong was fully autonomous and separate, as it was under colonial rule and then under early period after the handover, I think mainlanders just saw Hong Kong as a different place. They go to Japan, they go to the United States as well, and they see democracy. And yeah, they may decide that that's what they want. but I don't think Hong Kong was particularly a problem for China. It's by interfering in Hong Kong that China increases the very risk that it's trying to avoid. It's much like in the past, we're told it was trying to avoid the fate of the Soviet Union. So, well, it cracks down more in China, which is exactly what the Soviet Union did to get itself into trouble. So I think sometimes Pierre's right that this is how communist leaders see risk. But sometimes I think they're their own worst enemy. And so I think all of this has an implication for also this Bay Area as well.
Thank you. I know we've gone over a little bit. We'll have one last question here, and we have a question here asking what are the speaker's views on how the impact of the national security law will be on other countries. In other words, how will other governments and the United States, Canada, how they will deal with the changing situation in terms of trade, academic freedom, and travel.
I probably should jump in first because kind of in the lane I was articulating. Because of time, I didn't mention the national security law has global application. Unlike even the mainland national security law, which presumably respects foreign laws, foreign jurisdictions, domestic laws, the Hong Kong national security law applies worldwide. And we know that 5 or 6, I lost count, of people have already been the targets of warrants under the Hong Kong national security law. One of them is an American citizen who's director of the Hong Kong Democracy Council. I should say I'm on its board. We have heard rumors that reported in the Global Times that 30 other people are being targeted, but we're not told who they are. And these are people abroad. And so presumably they may well be people like ourselves, academics, who are operating abroad. So this creates a kind of caution for foreigners coming into Hong Kong to join universities and so on, if they have been involved in some intimate way in what's goes on in Hong Kong. They're sort of specialists in this area. They may want to avoid even visiting Hong Kong. All of this being said, this is why governments like the United States and several others have enacted a number of laws to provide for sanctions and so on. There's just a hearing recently over the Uyghurs this past week, which also involved Hong Kong, comments on Hong Kong. So their Hong Kong situation is being watched very carefully. And as I mentioned earlier, part of that is to sanction both individuals and companies who are viewed as complicit in what's going on in Hong Kong. And so in this latter aspect, it gets very much caught up in the sort of trade war between the United States and China, but also in similar problems involving, we know the European Union reached an agreement that was going to allow greater trade and so on. And now that's on hold because of this prickly relationship over how China's approaching these issues. So yeah, I think it has a very huge implication, and the global reach of the national security law sort of promises that.
I would perhaps only add that from my perspective, it is important, of course, to be aware of the provision that extends jurisdiction for crimes committed anywhere in the world, basically. And that is very concerning. But I think that in a sense, even more pervasive and profound is the fact that after all, Hong Kong is such a globally connected city. We've all worked in Hong Kong universities, in the Chinese University of Hong Kong before. All its universities have a lot of intense exchange and collaboration, sort of relationships, and of course, its civil society is or used to be really transnationally connected. I think that results also in the fact that all these global partners anywhere in the world have to be concerned about what happens to their counterparts in Hong Kong. They have to be increasingly concerned. And I think that in a sense, that's an even more, an even broader effect that the deterioration of the situation in Hong Kong has transnationally. And I think that I understand that foreign governments feel a responsibility to respond to some of the developments by, for instance, imposing sanctions like Magnitsky sanctions and so on. But I think that it is also important to consider the importance of continuing exchange and sort of keeping connected with what is an increasingly frail and increasingly, well, not frail, but endangered civil society and jeopardized academia in Hong Kong. And I think that so far as we recognize that that is important, I think we have to create more robust ways of safeguarding values in exchange and collaboration rather than sort of dismantling exchange and collaboration. Very briefly.
Thank you. Pierre, would you have anything to add there?
Well, I mean, I would only say that the last few months of the Trump administration saw the designation, the decision by the government to no longer recognize Hong Kong as a separate entity, and they were taking steps, material steps, to make that happen. So the danger was that all trade with the United States would be based on U.S.-China trade rules, that even the visa system may become a single visa system, and so on. So depending on how things develop here, I think there is a possibility that, if things go south and if the Cold War kind of Cold War II dimension, aspect shapes up, that more countries will act in this way. It's going to be increasingly difficult to justify the existence of a one country two systems when on the ground it doesn't seem to exist anymore. And if there's no system, why should we have two ways of treating mainland China and Hong Kong, in terms of trade, travel, exchanges, and etc. So it doesn't mean exchanges will disappear, but it means that they will be governed by, I guess, the common law of whatever relations country X has with China as a whole.
Well, thank you. And I want to end our panel by, again, thanking all three of our panelists for what I consider to be just a fantastic panel. I think it was a great way to bring to conclusion our three-day conference on deals and disputes. So again, on behalf of both of our centers, thank you very much for your participation today. I know it's quite late for you, Pierre, and getting later for you, Eva, and Michael is just starting his day out. But again, we deeply appreciate your help and support.
Pleasure and honor to speak to you. Thank you so much.
Thank you.
Now, I'd like to invite my colleague, Professor Ron Brand, to join me to help wrap up the conference. Ron, do you have some comments you would like to make?
Well, I do want to echo your comments about this panel. It was a wonderful way to wrap up the conference. I can't say it leaves us with optimism, but it leaves us with a much better understanding of events and what's the possibility is for the future. I would like to add a thank you to you, Jim, and the Asian Studies Center. I think that this conference demonstrates the kind of special structure at the University of Pittsburgh through the University Center for International Studies and the various area studies programs that allow an interdisciplinary look, or true interdisciplinary look at questions that are important. And as someone coming from the law school perspective, I really do appreciate that structure at the University of Pittsburgh and the way it does facilitate the kind of interdisciplinary discussion we've been able to have in this conference. And I think that is incredibly important. This panel emphasizes that very much. I guess I want to add some thank yous if I might, Jim, as we conclude the conference. I want to thank both of our keynote speakers, all of the panelists. I think it's been a wonderfully engaging set of discussions that we've been able to have. There are, however, people behind the scenes in these kinds of events that are important and make it happen. At the law school, Kim Getz and Paul Carroll have made the technical part of this run so smoothly. It's just been really nice to have that happen, because we all know how glitches in technology can make things difficult, but it's all gone very well. Nadine Hafaita at the Center for International Legal Education, our graduate assistant, has done many things behind the scenes to make things happen. Corey Parisi and Deb Hilton in the administration too, in all of the preparation. And Jim, I want to thank your colleagues, in particular Lynn Toratani and Rachel Jacobson, for all they did to help us prepare for this conference and to set things up. When things go smoothly, it's not because of those who are on the screen. It's quite often because of those behind the scenes. And I want to, again, at the University of Pittsburgh, the ability to cooperate between centers, between disciplines, and across the university is, I think, a very important aspect of what we do. And I want to say thank you to all of our colleagues for that as well.
Thank you, Ron. We appreciate your help and support. And this is the second conference that we've done together. And in fact, it's the second conference we've worked with Pierre, as a matter of fact, on. They have both been extremely successful. I think what this conference has brought home, in particular to myself and our director, Joseph Alter, is that over the past several years, we've been engaged in an initiative called Global Asia, where we've attempted to try and think about and to study the ways in which Asia is now affecting and influencing the world that we are living in. And I think the conference over the past several days has really brought forward two very important aspects. And that, of course, is China's Belt and Road Initiative, and then also, of course, the national security law and events that are taking place in Hong Kong. Both of them have very, have the ability to have a very deep and lasting influence in the way, we as academics and our students will continue to conduct research and to work in the 21st century. So I think this will not only cause the center to continue to embrace this idea of global Asia, but perhaps even to diversify it even more. And again, I want to thank all of our panelists and the teams at CILE and the Asian Studies Center for their help and support.
And thank you to all of those who have joined us to hear the presentation. We appreciate your being with us in Pittsburgh in this way. One of the downsides of COVID and the pandemic is that we can't get together in person, but one of the advantages that comes out of that is that we can have people from many more places together for the discussions that we do have. And we appreciate your joining us for the program.
Okay, so on that note, on behalf of Ron and myself, I want to thank everyone for participating. And I hope everyone has a good weekend and a good summer. And we hope to see you at another future events at CILE and the Asian Studies Center in the near future. Thank you very much. Goodbye.